Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Back on October 9th, 2024, Judge Stephen Hippler entered a redacted order governing further criminal proceeding and notice of trial setting. This is truly the blueprint for this case leading up to trial, which is why I prefer to refer to it as the pretrial and trial order. But nevertheless, I'm going to take some of the mystery out of this document, address such things as why is it redacted. I've never seen a redacted trial and pretrial order before. It begins by saying it is hereby ordered as follows in capital letters. Any prior scheduling order is hereby vacated, also in capital letters. That means it is null and void, and it takes the place of any prior such orders. And there was one. At the time when venue changed, and this proceeding moved from Latah County to Ada County back in September of 2024, Judge Sean Judge had already entered a pretrial and trial order, and there were certain dates attached going up to a jury trial date. Those dates were all vacated, as well as the trial order, and that's why if you look on the case summary page, you're going to see certain things canceled. Those are the dates attached to the pretrial and trial order for Latah County, which was vacated and replaced with this order of October 9th, 2024. This order continues as follows. Voir Dire and trial setting. Under Section A, we're on page 1. Jury questionnaires will be administered approximately, and it says redacted, date 2025. So this is the redacted portion of this order. No other portion of this order is redacted, but as it relates to when the jury questionnaires will be administered. This means when will they be disseminated? And those questionnaires will be filled with questions to determine if they have any biases, any prejudices, anything that either side might be concerned about, that they might not be able to receive a fair trial, and therefore that this potential jury member should be struck from possibly serving on the jury. That's usually done when the jury panel member is called to the courthouse to serve potentially at a trial. Not everybody who is called for jury duty gets to serve on any trial in any case. These are the prospective juror pools. Will be administered approximately redacted 2025. Now there's some clues in this document. I'm going to show you where. That's going to give us an idea of when these questionnaires will be administered. You have to go to Section D of this jury and pretrial and trial order. You go to a portion of the document that's called D, Trial Materials, and it says here under the first paragraph, proposed jury questionnaires shall be simultaneously filed under seal by March 24th, 2025. So what that tells us is the state and the defense are going to simultaneously, the same date, file their proposed questions for the jury questionnaire. Proposed, because there's a process that's going to happen before the ultimate and the final jury questionnaire is developed. So the proposed jury questionnaires by both sides shall be simultaneously filed under seal. So this is not anything you're going to see on the public docket by March 24th, 2025. So we're now approaching the end of January. Probably not a bad bet to take that both sides have been working on. They might have jury consultants help them with these questions. These are people that are experienced in selecting jury members based on the facts of a case, what type of a case it is, if it's civil or if it's criminal, that the state and the defense, not necessarily, but this is what attorneys do. They consult with specialists in the field to help them determine what's a good question for us to be able to potentially weed out someone that we might not want on this jury because they may have prejudices, biases that may not be apparent. There's things that can be asked, and these jury consultants are extremely good at identifying what they are. In any event, depending on whether or not, irrespective of whether or not jury consultants are attending to these matters, the deadline for both sides to submit their proposed jury questionnaires under seal is March 24th, 2025. Objections. So what this means is once these documents are filed by the state, the defense is going to see the proposed questions. Same with the other way around. So any objections that one side has to the other regarding these jury questionnaires have to be filed by March 31st, 2025. So in other words, if the defense sees a couple of questions that they want struck off the prospective jury questionnaire form, they would go ahead and they have to raise their objections by March 31st, 2025, or forever hold their peace. Same with the state. Now, a sealed and closed hearing on the proposed jury questionnaires will be held on April 16th, 2025. So this is a hearing that Judge Hippler has already set on the calendar. It's a date certain, April 16th. And what it is to discuss the proposed jury questionnaire so that the court can come up with whatever the final is that will then be disseminated to the prospective jury panel. Based on this paragraph, we can make an educated guess that this jury questionnaire will not be disseminated to anyone, whether it's before they report in July of 2025 to the courthouse, or it is at the time that they do, or wherever they're being told to report. Will not happen before, I would venture to guess, before the end of April. If it's going to be done prior to the trial because of concerns that they can't find an unbiased jury panel, they may do it before. They may do it at a place that's not the courthouse. We don't know. Everything is under seal. We go back to page 1. Let's continue on. Voir Dire shall commence on July 30th, 2025 at 9:00 a.m. And what happens then is that this jury pool will then be asked questions by either side. And the whole objective is for the state to try to identify jury panel members that it feels will be not biased toward their case. Same with the defense. That is Voir Dire. July 30th, 2025 at 9 a.m. In my opinion, this is the start of trial, not August 11th, for two reasons. If we look at the next paragraph, it says here, the jury trial shall commence on August 11th, 2025 and run through November 7th, 2025. Now, we know if you have been following this case, Judge Hippler is very organized. Time management is very important to him. He likes to set things in advance. But what if a jury panel is not found? What if they have to keep striking jury panel members? And they can't seat a jury panel by August 11th with the necessary alternates, because what they do is they select a number of panel members, but the panel members don't know if they are the ones that will, at the end of the case, go into the jury room and deliberate, or if they're alternatives, because you want them to pay attention. If somebody's there as an alternative, they may not be paying attention as much as somebody who knows that they're going to be deliberating. And why are alternatives needed? Well, sometimes things happen. People may sit on the jury panel and then they may get sick, or there may be another issue that comes up and they need to be relieved from jury duty, and then you need someone else to be able to back them up rather than have to stop the case, start all over again. So that's why that process occurs in these jury cases. The other issue is it's going to run from August 11th through November 7th. This is including of the penalty phase. Okay, so there's actually going to be two trials. If in the event Mr. Kohberger is convicted, you're going to have the case in chief, which some people call the guilt phase. I like to call it the case in chief, because again, a defendant is considered innocent under the eyes of the law and the Constitution. The guilt phase seems to suggest guilt. That's just my opinion, how I like to look at it. Case in chief, this is when the state has to proffer evidence in front of this jury that demonstrates that Mr. Kohberger, according to the state, is guilty, is charged beyond a reasonable doubt. If Mr. Kohberger is acquitted, found not guilty, then it's over. That's all that happens. But if they go into the penalty phase, that's the second part, then there needs to be another trial as to what's the sentence going to be, keeping in mind that the DP is on the table. This is a capital case. What if it takes longer for the case in chief than anticipated and this trial goes on beyond November 7th? So I think that these are dates that the court is hoping that they may be able to stick to, but may not be possible. It all depends. This will now conclude this episode of the Indie Zone. Thank you for joining us here today.